plant material that is dried falls in the category of usable, and only that which is usable can be counted against the person's weight. What instead happened? The material that I described, the recently cut plant into this branch with buds and leaves and whatnot as they hanging and being worked on, is thrown into a bag, it's weighed, and that's your case. That's the case they gave me. You know how many cases we've had like that? If I was to cross-reference 100 cases that came through Comorn Law last year, I would say that scenario probably plays out to, I don't know, 50% of the cases, I'd say. I don't know. Okay? And there's a little disconnect here. It's a cute little disconnect if you're voting for the blue. It's that it's processed. Processed.
It also indicates the police don't know the meaning of the word dried.
I'm telling you, Alan.
Or usable material.
I'm telling you, Alan, the word that they use, process. There's plants and processed marijuana. All processed marijuana to them is usable. That's the logic. Trust me. But let me tell you a little history about it, Charmy, of how this thing went down. Because if it's ambiguous and there's not certainty or clarity, you can arrest. So they say. Because you have to be in unambiguous compliance with the law. So the more ambiguity, the more uncertainty, the more of that which we're uncertain of, that you find yourself debating. No, it says the dried. Police officer, that's drying. It's in drying Rex. Tell it to the judge. Wrap him up. Let's go. It's all processed and usable. Usable is all usable. This is the logic.
Yes.
So let me flash forward to the amendments. Bill Schuette came on board there, stirred it up quite a bit. I think he introduced like 900 pieces of legislation, trying to amend the crap out of the law. Legislature, I don't talk nice of him, but they did, in fact, not listen to him at all. And I remember vividly during some of these hearings, there was state police that were testifying. I testified with, what's his face? Remember that, Jimmy? Stecker testified, and I was there, and what's his, my buddy from long ago. Anyways, as we discussed this, the Michigan State Police came forward, and Ken Horn, who was the representative, Jamie Lowell, come on, from, where was he from? Frankenmuth area is on the board for this panel. Kavanaugh, who else? Who else on the panel? Remember, it was not...
Come on, wake up.
Lisa Brown,
Jeff Irwin.
Yeah.
What's his
everyone wants
face?
to know that Michael just woke Jamie up. He was in a dead sleep with his little dog here. And he said, hey. And Jamie just spit him out. That's why you're here, Jamie. We love you.
Jamie
Thank you.
does that every now and then.
Sorry, Michael.
That's good.
He dozes off.
But Representative Horn said to the representative for the Michigan State Police, hey, state police representative, this is a big thing that's going on. We're in the Judiciary Committee. There's amendments that are being suggested that, 3/4 of the people to vote on. We're trying to get a feel for this. People are testifying. We're trying to figure out what's going on. Ken Stecker's telling the story. You got these two guys there from the MA saying it's a disaster. You need a patient's bill of rights. Remember we were pushing that thing for a little bit? What's real? Can you give us some insight? Does the law enforcement community, what's their opinion on usable marijuana in light of the MMA? They said, we don't have one. We don't have an opinion about usable marijuana. This ambiguity from 2010, 2012 continued to 2013, to 2014, to 2015, to 2016 until this case came out in 2017 called People versus Emmanuel. And in this case, there had been other cases before this, specifically
Randall and Roquefort.
Randall, unpublished, Roquefort, on appeal, not resolved yet. But the case of Manuel is significant because it said what fucking part of the definition of dried is not clear. Drying is not dried. Let me say it again. Court said, we're going to read this statute as if each word means what it says. Not the way law enforcement wants us to read it or interpret it. When I see the word dried, I'm not going to say it's processed. It's dried, not drying. So, this case comes out, put an end to this so challenging to define, so nuanced in its ability to grasp it of what is usable. Oh, it's so confusing. Dried. You know why? Because very little of the marijuana actually falls into this category along the way. The devastation of this ruling to the law enforcement community is that if it is not dried, I'll give you this. I didn't know that they were going to go this far. I didn't know what the Court of Appeals was going to do on this because it seemed to be kind of against. But they said that if it's not usable, it doesn't count. It might as well be, they didn't say this, but for purpose of the weighing of usable marijuana that you're going to assess in terms of whether you're over your 2.5, it doesn't count. It might as well be invisible. Might as well not even count. That 10 pounds of soaking wet marijuana on the drying racks that they would put into a bag and take in, and you were inevitably going to defend this case as a Section 8. There's no immunity. Ha ha ha, counsel. I find it hard to believe that the voters of Michigan intended 10 pounds to be for medical purposes. Ha! I'll see you at your Section 8 hearing. Ha! Right? Today, by this simple ruling, a little bit of logic of how the plant's supposed to be grown, done. Do you know how much carnage has taken place over this? When I say 50% of my cases, think about the other people that didn't get a defense or didn't, they just got dragged into court and didn't know, get their head spin around, had some lawyer tell them, blah, 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 law doesn't say, and just, capitulated or whatever. They had to meet a judge that wasn't even, someone argued it and the judge wasn't, they didn't appeal or whatever, they pled guilty and could appeal, So this thing to me is the most amazing. And while we're at it, might as well talk a little bit about Carruthers, one of the dumbest cases that's ever been issued in the history of the world. The suggestion that people were destined only to smoke, patients could only smoke, and that's it, and the voters got to smoke. I remember Jessica Cooper quoted when there was like 50,000 patients. I find it hard to believe that 50,000 doctors recommended their patients smoke marijuana. But then Carruthers are like, you can't make brownies. I mean, it's like, which is it? Which, stand still so we can get a target there, But Carruthers, of course, is this awful case that made no sense and really is a terrible effort. I still have a tough time reading it, even though it came up in a case that we have in, some time machine I have to go into to go back to litigate. It's weird. I got to go back in time. But the beauty of this that I say, I'm sorry, T-Pain, but I got to just finish my point here. This one case, Manuel, this one opinion, Frank Tulusky, God bless him, our professor, we use him in our cases. He was referred, and he's the referred to in the case as the expert opinion that can help, and did in this case determine what was dried and what was not, what was usable. But it just ended this nonsense, this game, this gotcha, this cat and mouse of what are you going to do with my usable? What can I do with it? What is it? What am I supposed to? I remember these discussions. What do you do? Keep it in alcohol? Keep it, perpetual grow. People can't harvest at the same time. Freeze it. We've just been battling. Who's got the most, and how are you going to define it? For certain, label it not usable. But one opinion based on logic, it's over. The game is over. They're called out. Every interpretation that they had, every justification, it's over. I mean, how does that happen? How does the way that they go about it and get away with for all this time, one opinion, it's over. Can't do it anymore. It's wet. But they're still doing it. We got cases still going on. And we're going to have to, get rulings by judges. But it's all right. Carruthers, same thing. We're going to rush you for some brownies, some oils. It's not a plant. What do they do to that? 4210. Not only 4210 saying these are things that you can possess, we're going to create a greater volume of it that you can create. And if you've been screwed by this terrible interpretation that the law enforcement community thrived on in ways to pull people out of immunity. Can't have brownies. Oil's illegal. Some families were torn apart. Some that are trying to make synthetic THC. Just twisted, sick stuff.
And this is the end result. Families are torn apart.
Just a twisted, crazy shit.
It destroys families. It's just, look at you yelling at not week after week after week at the injustice, the lies that are told in the courtroom. And I can't believe you're still walking around with your head square on your shoulders anymore. The madness. The cops lie every time I'm in the courtroom with you. The cops lie. You catch them lying. What do the judges do? What happens to them? What happens?
It's been listen. There's been an abuse, but think about so all this time they've been arresting people and torturing them.
Yeah.
The legislature, it's not me. Legislature passed this law and says that going backwards. We they say in a retroactive curative, they say in this law when we were amending the law because we were not able to honor the will of the people by preventing the vast number of patients identified as debilitated from getting arrested.
It was a statement that the courts of this state were wrong.
And the legislature failed them too.
The legislature did, but the hardest part of getting 4210 to the point of where it was at in the beginning was just getting the legislators to believe us.
Okay, what is 4210? What is that
That's
law?
the
For your
medical
listeners,
Yeah,
make sure listeners know.
So that's the bill that addressed the issue that the Carruthers case presented, which is that usable marijuana now didn't specifically include brownies in this case, but that was
4210 is the bill that allows for marijuana infused products and brownies and
Concentrates.
different weights and extractions.
Exactly.
Yeah, but 4210 was the House bill. The actual law is Public Act 283 from 2016, and that Public Act actually amended Section 4 where it says the person can have 2.5 ounces of dried usable marijuana or equivalents, and it goes on to spell out what the equivalents are. For example, if it is brownies, like we're talking about Carruthers, it's 16 ounces of brownies equals 1 ounce.
It doesn't say brownies.
No, it says solid.
All right, well, I was using that as an example. Solids are 16 ounces, fluids are 30 ounces, and of course, gaseous equivalents are 7.5 grams. Everybody knows what that is, right?
All right, so we're talking about that. So it's just so then all of a sudden the law changes and it's not just that they were wrong and they've been abusing people. They're wrong when they were doing it. All the shit they took and all the arrests and the records, all wrong. Basis, all wrong. Just making shit up, dangerous, blah. The lab, crime factory, blah, blah, blah. And here's the other one, Charmy, the good old People versus Ballsma Round 1, the so-called enclosed lock facility. It's a case where a fact often forgotten where the building code inspector breaks it. Thinks that someone's growing plants in an unregistered building. There's a open room. What?
We're going to have to take a quick commercial break.
I was going to ask you how you feel.
The
felt
grandfather
about
of medical marijuana.
Michael, how did you feel about the illegal transport law?
The grandfather. No, he's the godfather.
Somebody actually called me today and talked to me about that.
And on that committee that we brought up a long time ago, Walsh and Kurt Heiss were also on that. And Walsh was the chairman.
Struck down by the Court of Appeals.
Josh just hijacked the craft.
You know what? The Ballsman thing is important because this is, and I just want to say this. Okay, I'm going to finish on this, and I'm going to go to break. and We'll come back with Tim Beck. We'll get him in the queue in a second. But Ballsman is this other screw the shit, because the idea that the underlying basis of Ballsman was not allowing people to possess more plants than you're allowed to. That's the key. It's not whether someone has access. Someone could crawl through a wormhole and get into your room, take your key when they never would because it's hanging on the door. That's not the point. It's not what you might do. It could do. Anything could happen. Pigs could fly one day. Who knows? They took this case and said Ballsma loses because he testified he's allowed to have 24 plants and he felt, sang to, watered, moved around all the other plants. What part about he was not possessing not more than 24 plants do we not understand? It's an easy case. It's about possession. It's about possession. It's not about possible access and it's a violation because some stuff's going on there. I even think that the interpretation of Ballsma could mean if Jamie Lowell is allowed to have 48 plants and Michael Camorra is allowed to have 48 plants, and we live in a place that there's 48 plants in the grow and 24 of them are mine and 24 of them are yours, and I go into that, I don't have plants anywhere else, you don't have plants anywhere else, we share that room and have access to my 24 and you're in there as well. I'm not possessing and could never possess more plants than I'm allowed to, and neither could you. And inside the room, I don't touch your plants, you don't touch mine. That, I think, is, I'm not advising that, I'm not telling people that, but the possession factor of that. But the point is, Jim, as I'm closing it out here, is that the Manuel case that I was talking about, that ended this crap about the wet marijuana, that it has to be dried. The circumstances of Manuel winning were the following. He was buying marijuana plants